Okay, we're back for our final segment, which is going to be on various dispositive motions. Okay, now there's differences between Rule 12 motions, Rule 56 motions, Rule 50 motions, Rule 59 motions. I'm going to go briefly through all of them. All right, Rule 12 motions. Now there's Rule 12E motions for a more definite statement. Not going to get into that. Motion to strike, not going to get into that. But I will get into the Rule 12B motions. All right, the defenses, the 7 defenses listed in Rule 12B can be asserted either by putting them in your answer or by raising them by pre-answer motion. All right, there's a big difference between the types of motions. Some of them are disfavored, some of them are favored, and then there's the most favored defense. And I get these terms from Professor Glannon. The disfavored defenses are the defenses 12B, 2 through 5. That's going to be lack of personal jurisdiction, improper venue, improper process, and improper service of process. All right? These are defenses that must be asserted in your initial response or they are lost forever. There's one caveat to that, but the basic rule, I call it the initial response rule. Well, I don't know where the term came from. That's what I call it. I probably got the term somewhere else. Put them in your first response. If that response is an answer, put them there. First response, pre-answer motion, put them in there. If those defenses are available to you at that time, and usually they're going to be, put them in your initial response or they're lost forever. There is one exception to the initial response rule, and that's this. Okay, so main rule, IRR, initial response rule, except amendment as a matter of course. What do I mean by that? If your initial response is by way of answer and you omit one of these defenses, you can rescue the omitted defense if you make a proper amendment as a matter of course. So for example, you serve your answer and you say, no PJ. And then within 21 days of serving that answer, you're like, oh crap, I forgot to include venue. Well, then you make an amended answer as a matter of course, all right? And now it says no PJ and no venue. That's okay. Even though your initial response didn't have the venue objection, you added it by an amendment as a matter of course. But remember, that only matters if your initial response is an answer, okay? Because of time, unfortunately, I don't have more time to get into that. All right, but I wanted to give you at least the basis. Favored defenses are 12B 6 and 7. 12B6 is failure to state a claim. 12B7 is failure to join a party required by Rule 19. Those can be raised through trial. They don't have to be a pre-answer motion. You can raise them for a motion for judgment on the pleadings or even through trial. Okay? The most favored defense is the 12B1 defense of lack of subject matter jurisdiction. And subject matter jurisdiction is so important that the court has an independent duty to raise the issue of its own subject matter jurisdiction sua sponte. And that can be raised by anyone, the parties or the court, through trial and through appeal. Okay? So those are your basics of the Rule 12 motions. Let's move on. The next one is Rule 56, motion for summary judgment. Summary judgment is saying to the court, hey, the facts that are material to this lawsuit or this claim or this defense are just not in material dispute. And because the facts are all predetermined, they're not in material dispute, here's the facts, and you, the court, can decide this defense or this claim as a matter of law. Okay? So in other words, for you to get summary judgment, the moving party has to show no genuine issue of material fact, and then the court decides, if this is met, whether or not the moving party is entitled to judgment as a matter of law. Okay? Now, if you're the plaintiff moving for summary judgment on your own claim, then you're going to have to show that there's no dispute regarding all of the elements of your claim. So So for example, on negligence, I'd have to show not just there's a duty, which is a question of law, but there's no dispute regarding breach, no dispute regarding causation, no dispute regarding damages. I have to, on every element, show that I must win. There's no dispute regarding all of those elements. So that's what Glannon calls, I believe he calls it the all elements summary judgment motion. Okay? That's kind of hard to get, right? Now what if you're a defending party, right? I sue you for negligence. All right? You don't have to prove or disprove all the elements. You just have to show that I, the plaintiff, am going to lose on at least one necessary element. So if I sue you for negligence, you can knock out one leg of my claim. Think of the claim as being a three-legged table. To knock it over, you need to just cut out one leg, right? So say, for example, you're the defendant, I sue you for negligence, and you say, you know what, Nathenson just has no evidence whatsoever of breach. Think of Megan Stewie, right? Let's assume, after discovery, there's no evidence that the defendant was driving the car. No evidence of breach, right? So as long as the defendant can show there's no genuine dispute regarding breach, in other words, that there's not evidence that's admissible that would show the defendant breached a duty owed to the plaintiff, all right, then that defendant will be entitled to judgment as a matter of law because the plaintiff is lacking in admissible evidence on at least one element of the plaintiff's case. Now, in this scenario, when a defendant is moving for summary judgment, there's two ways that this person, the defendant, can move for summary judgment against a plaintiff's claim. One is to put forth materials. And that could be affidavits, depositions, admissions of record, documents, etc., etc. Put forth materials. But a second method that could be used is the Celotex method, which is to show the court that the opposing party lacks admissible evidence from which a jury could find in its favor on that issue. So what I described in my hypo just a moment ago was the Celotex method. The defendant says to the court, hey, you, the plaintiff, don't have any evidence showing that the defendant was driving the car, and therefore, since you lack that information, I, the defendant, am entitled to summary judgment. Okay. So now, unfortunately, we're running short on time. So what I'm going to direct you here towards are two things. First, I have a video on my website regarding summary judgment from the spring review. And additionally, if you go onto the website, I have a nice handout that compares Rule 12, Rule 56, Rule 50, and I think Rule 59, but I can't remember off the top of my head. So you can compare all of those, the timing, the subject matter, and all of that. Now, Dean Singer, I see that we're at 6:30. Now, I think we need to make a judgment call here. We've been going for 4 hours now. I can continue, and I'm happy to continue, but I can see the noble faces here are starting to drag. They're happy that we spent the time together, right? They're looking forward to more review sessions, but I don't want to completely burn them out either. So do we cut it off here and I refer them to additional materials on my website, or do I finish out the motions?
How much time does it take you to finish out the motions?
Oh.
Rush through it.
Well, I'm kind of rushing through it at this point. I'm honestly not happy with what I'm doing now because I feel the time pressure and I'm kind of boom, boom, boom rushing through it.
Then I think we will end the session now. If you have questions, certainly you can ask Professor Nathenson now, or as he said, he's going to be around. I think it's in the best interest of everybody, including Professor Nathenson, because this is a tough thing to lecture this long. We will end the session, but let us please thank Professor Nathenson.
Thank you. To really thank me and to thank yourselves, everybody study hard, stay rested, stay healthy, and every single one of you, please pass the bar exam, okay? All right. Thank you.
Before you leave, Amar has